All right, thank you, Professor Byer. Our next speaker is Mr. Ed Smith. Mr. Smith is senior counsel with Stevens Guthrie in Dallas, Texas, and he specializes in estate planning, administration, and litigation. Mr. Smith attended college at North Texas State University and obtained his law degree from Southern Methodist University. He's board certified in estate planning and probate by the Texas Board of Legal Specialization and is a fellow of both the American College of Trust and Estate Counsel and the Texas Bar Foundation. Mr. Smith is a recipient of the Lifetime Achievement Award from the probate sections of the Dallas Bar and State Bar, as well as the Morris Harrell Award for Professionalism from the Texas Center for Legal Ethics and the Dallas Bar, which is the highest award presented by the Dallas Bar. Mr. Smith's presentation today is entitled Professionalism, Dead or Just on Life Support. Please join me in welcoming Mr. Edward Smith III.
Well, I'm sure some of you would prefer a rousing speech on the inclusion ratio. However, you're going to get a lawyer talking about how lawyers ought to behave. Oh, well, it's better than a root canal. Well, what's this all about? As you look at the outline, you'll see this debate has been going on for 20 years. Well, it's because the judiciary and the bar has perceived that lawyers don't know how to act like lawyers anymore. And in some states, it's reached the point that instead of being rules that are aspirational, the rules are mandatory. And they can lead to discipline if you violate them. And sooner or later, it'll come to Texas. So let's first look at some of the causes. Well, I read so many bar journals, law review articles when I prepared this speech, and I've given it all over the country to bar associations, to judicial meetings. And some young lawyers have been labeled baby sharks, that they don't know anything except billable hours, incivility, winning at all costs. But who did that? My generation. My generation was the one that put the emphasis on billable hours, winning. And then suddenly, we've realized we may have made a mistake. And so I've been trying for the last 10 years to rectify these mistakes in writing and speaking everywhere I can to try and change the trend. Well, what are some of the causes for this decline in professionalism? Well, for one thing, there's been a general decline in ethics in the country as a whole, business ethics. We have one car dealer in Dallas who's recently quit saying, if you can find a better deal, I'll just give the car to you. At least he's changed that commercial. Well, there are more lawyers coming into the system. Some people have cited. And the popular introduction of the so-called bulldog lawyer who goes to tear up the opposition no matter what the cost. And there's an increased competition for the elite client. One of my colleagues is convinced that civility declined in my area, in Dallas and Fort Worth, when the airport was built, and I thought, how in the world can you tie that in to civility with lawyers? He said, well, when the airport was built, the multinational corporations came to the Metroplex. When the multinational corporations came to the multiplex, then the demand for better and more complete legal services came to law firms. When that came, there was a phenomenal growth in law firms. With phenomenal growth came competition. With competition, the growth of incivility, and so on, and so on, and so on. Well, so what is it say? We call professionalism. Some people have understood it to mean that it includes civility, both among lawyers and with the judiciary, integrity, respect for the rule of law. It encompasses more than a minimal ethical standard. It means principled conduct, commitment to the client, the public good, etc. I'm in my 52nd year of practicing law. I've tried hundreds of lawsuits. I've seen the good, the bad, the ugly. I've seen lawyers treat each other like they ought to be in a ring somewhere with gloves on. I've seen disrespect for the courts. And I don't like it. And you shouldn't either. Well, there has been a reaction. There is a thing called the Conference of Chief Justices. And what the Conference of Chief Justices is all about is every Chief Justice from every state in the United States of America and the Chief Justices of Puerto Rico and Guam get together twice a year. And they have educational seminars and they discuss events that concern them. As far back as 1996, they were concerned about this problem and they made some recommendations. And some of these recommendations were to establish mentoring opportunities, to establish opportunities for solo and small firm practitioners, to increase the dialogue in law school. And I understand from Professor Byers, we talked about this. We are fortunate enough that he comes to Dallas once a year and gives his case update. And I asked him on one of his visits what Tech was doing about professionalism. And he told me that they're addressing it here. And this is where it needs to be addressed first, in the law schools. Because traditionally, law schools have taught rules of discipline. You violate the rules of discipline, and you do it in an egregious enough manner, and you lose your license. But right now in Texas, the rules of professionalism are more aspirational than they are enforceable by discipline. Of course, the courts can impose sanctions. There's always going to be that. And so this Conference of Chief Justices addressed this and made some recommendations. And they're easy enough for you to read. I don't want to have to take your time to go through them. But I do want to talk about the Dondi case. Now, my copy has the pages on it. Your copy up at the top looks like the pages have been kind of obliterated. But the Dondi case is on page 3 of the outline. Now, this particular case has probably been cited more than any federal district court case than you'll find. And what happened in Dondi was all of the judges seated in the Northern District of Texas said, we have had enough. We've had enough of lawyers wasting our time with discovery disputes, with bickering among themselves, and you're wasting our time. And they said that this problem has become so pernicious that it threatens to delay the administration of justice and to place litigation beyond the financial reach of litigants. With alarming frequency, we find that valuable judicial and attorney time is consumed in resolving unnecessary contention and sharp practices between lawyers, judges, and magistrates. And they're required to devote substantial attention to refereeing abusive litigation tactics that range from benign incivility to outright obstruction. In other words, what the court's saying, we're here to be judges, we're not here to be referees. And we're going to impose some standards of conduct, and you're going to abide by them. And they listed some standards of conduct that we're going to apply in the Northern District of Texas. I'm not going to go over all of them, but some of them, lawyers shall treat each other, the opposing counsel, the court, and members of the court staff with courtesy and civility, and conduct themselves in a professional manner at all times. Another one that's clear and dear to my heart, the lawyer should not use any form of discovery or the scheduling of discovery as a means of harassing opposing counsel or counsel's client. I have sat through many depositions where it seemed to me the whole purpose of the deposition was to punish his opponent and not to gather facts. And that's what discovery, that's not what discovery means. Discovery is to find out facts that are beneficial to your case. But clients have come to me and said, I want you to reach down their throat and turn them inside out in that deposition. And I won't do it. I can give what I need to know. I've just been better prepared than the opponent, getting the facts I need, and then using them to their best effect when the trial eventually comes. Interestingly enough, one year I got to attend the meeting of the Conference of Chief Justices. They didn't care a thing about me. My wife was president of the National College of Probate Judges at the time, and so I got to tag along. But one of the panel discussions at the Conference of Chief Justices was the Dondi case. So the effect of Dondi, the Northern District of Texas District Court case, had made it to Washington, D.C., to the Conference of Chief Justices out of their concern for how lawyers behave in their interaction with the judiciary. It's important at the highest levels, people care about how lawyers behave. Well, so what are we going to do about it? In a recent Bar Journal, you might have noticed that this is the 25th anniversary of the Lawyer's Creed. The Lawyer's Creed is what we say as lawyers and judges say as judges. This is how we're going to conduct ourselves. I believe every lawyer ought to have a copy of the creed in their desk. So when they get frustrated enough, they can look out and look at it and say, this is what we believe. And it's set forth on page 4 of your outline. But there's some things in here that are worthy of note. I will treat adverse parties and witnesses with fairness and due consideration. A client has no right to demand that I abuse anyone or indulge in any offensive conduct. As I mentioned earlier, I'm in my 52nd year of practicing law. I gave up trying jury cases 2 years ago. Albeit I didn't try that many jury cases in my career, and most of them were in the early stages of my career. I never lost a jury trial. Sometimes after the case was over, members of the jury would tell me, one of the reasons you won your case was because you conducted yourself in such a gentlemanly manner. One time, we settled a case, and it was a probate will contest. We settled a case after opening statements. And one of the jurors came up to me and said, Mr. Smith, you would have won your case. I said, how could you possibly have determined that when all we did was opening statements? And she said, you told us what the case was about. The attorney on the other side spent most of his time attacking you. And all you did was look back at him and smile. And we knew that you knew when you got to the case you were going to thrash him. So, you don't have. You win a case because you're better prepared than the other side. You're better prepared on the facts, the law, the testimony. You don't win a case by being nasty. People pick that up. They see that. So, incidentally, on the lawyer's creed, one of the judges in Dallas called me last year, and he said, Ed, I got a problem, and I know that you go around talking a lot like professionalism, about professionalism. I have a problem. I said, okay, Judge, what is it? He said, I've got two lawyers that are tearing each other apart every time they come into the courtroom. And I can't control them. And I'm afraid someday one of them's going to pull out a gun and shoot the other one. what do you think I ought to do? I said, well, Judge, it seems to me it's a twofold problem. One of them's easy. If one of the lawyers pulls a gun, just have your bailiff shoot him. The other one, I would give each one of those lawyers a copy of the lawyer's creed. So you're going to read this, and you're going to abide by it the next time you come in my courtroom, or I'm going to sanction each of you $20,000. And he said, do you think I can get away with that? I said, I've been married to a judge who was a judge for 27 years. And a judge can get away with anything until a higher court tells them they can't. He called me and told me that it's like two lambs had walked into the courtroom the next time they met. I want to talk to you about something that's near and dear to my heart, and that's mentoring. 7 years ago, the Dallas Bar Association adopted a program called Transition to the Law. Any one-year lawyer who wants a mentor can request the bar to give them a mentor. And that lawyer who agrees to be a mentor must commit for that year that he or she will attend a bar meeting with the mentee where they'll be taught everything from how to avoid malpractice to billing. There'll be lectures on professionalism, things that every lawyer should know. The one stipulation is the mentor and the mentee cannot belong to the same firm. Well, why can't the firms do that themselves? I had plenty of mentoring when I was a young lawyer, but I think when I started practicing law, when I spread it out over 30 days, I was making something a little more than $15 a day. So there was plenty of time for mentoring. As a matter of fact, my senior partner, who was a litigation partner, the first draft, maybe the first 5 drafts, I brought a pleading, unacceptable, never looked at it. On about the 5th draft, he said, Ed, I think maybe we're getting somewhere now. Finally decided to look at it. And maybe on the 7th or 8th draft, we had something I could file. You can't do that today. With the salaries that lawyers command and the increased salary for entry lawyers puts increased pressure on partners, and they just don't devote that kind of time to it. The transition to the law problem allows this young lawyer to meet with a seasoned lawyer who can not only teach them the fundamentals of their field, but at least in my case, I try to teach them how to be a respectable lawyer. I've had 7 mentees now. I'm meeting my latest one for lunch next Thursday, and we will attend these meetings together. So it'll be the 7th time I've heard these things, but it'll be the first time that I've met with each one of these lawyers. My first mentee is now a partner in his firm. He's making a name for himself in our field of probate litigation. I can't tell you how proud I am of him. He called me one day and said, "Ed, I'm trying my first jury trial tomorrow, and I have no idea what I'm going to do." And I said, "Come over, let's talk about it." He came over at 5. He left at 11 o'clock that night. And I told everything that I knew that I could tell him in that period of time. And I said, "Now, this has got a huge risk to it. But if you pull it off, you're going to win your case. Your first witness is going to be the contestant. Put him on the stand and destroy him. And there goes his case." He did it. It worked. He won the jury trial. I couldn't have been prouder than if I'd been trying the case myself. Sometimes you find out things that have nothing to do with the field you're trying to help them with. My last mentee last year, I took her to lunch and I asked her how things were going. And I noticed she was tearing up. I said, "You're not happy with where you are you?" And she said, "No, I'm not." And I said, "Well, let's talk about it." Well, the partner she was working for was very demanding, arbitrary, kind of person you don't want to work for. Well, what are you going to tell somebody? She needs the money. And I tried to encourage her ways to keep at it till she could afford to do what she wanted to do. Sometimes you have to strike out on your own. I've been everything from a senior member of a firm that now has 1,200 lawyers and is worldwide to a sole practitioner. So you can make it. If you've got the skills and you've got the drive, you can make it. If you're a mover and shaker in Lubbock, or you know someone who's a mover and shaker in the Lubbock bar, and you don't have one of these programs, then I'm going to encourage you to start one. Because the lawyers who agree to be mentors, I think, benefit more than the mentees. For one thing, it makes you young again. It's great to be with these young lawyers that have all the idealism that 50 years have beat out of you. You get to renew that enthusiasm that you once had yourself. And suddenly you bring to mind things that you'd forgotten, things that meant something to you when you were young, things that somewhere got lost in billable hours, in winning, and whatever drives lawyers. And once you bring it back to yourself and you remember how it was, and your idealism, and your experiences, and things that seem no longer important, but when you think about them, they were watershed moments in your practice. And you can share them with someone who's got a blank page, who's eager to know what you know. And they're not going to get it anywhere else but from you. It's awesome. And I can't wait to meet this year's. It's going to be interesting finding out about him and seeing what I can do to help. Well, there's been some writing on some of the problems that are intergenerational. There are 4 distinct generations practicing law now. The silent generation, who were around before or during World War II, the boomers, X generation, and the millennials. I don't think it takes much to understand that there's some differences in how we think. I'm the silent generation. The way the silent generation started practicing law, they starved you to death to see how long you could take it. You worked incredibly long hours. And then one day you had him made. You had him made financially. You had him made socially. And it was just like a whole new door had been opened. Some of the millennials, some of Generation X want the same thing as instant gratification. Some of the older generation is saying, that's not how it works. That's not the way I did it. And so that in itself causes problems. Some years ago, I was a managing partner of a 55-employee law firm. The young associates and young partners nicknamed me the professor because, fortunately or unfortunately, sometimes I get a little professorial, maybe often times. And so at 6 o'clock one night, a young man came to my office and said, "Professor, may I talk to you?" And I said, "Sure." And he kind of looked at his feet. He said, "Professor, can you give me some idea when I'll make as much money as you do?" And I said, "You'll never make as much money as I do." And he had a look on his face like I just hit him in the face with a cold 6-pound bass. And I said, "Let me tell you why." I had been divorced and was single at the time. I said, "I'm divorced. I have no children. I have health issues. The practice of law has been my whole life. I'm very narrow. The last person in the world you want to try and emulate is me. What you want to do is have fun with your kids, enjoy being with your wife, and let compensation not be the tail that wags the dog. Whatever you do, if you put your family first, you'll be a success." Ultimately, he left the firm and went on to be general counsel of a corporation. I see him occasionally. He's in his 50s now, and he's enjoying life. And he always thanks me. for having that discussion with me. I learned more from that discussion, I think, than he did, because I changed my life, too. I got married again to a wonderful judge. I began to see that there were other things in life than practicing law. And life has been good. I want to leave you with some final thoughts. That these rules and creeds that we adopted, to me, are more than aspiration. They're how a lawyer should conduct themselves at all times. We've all heard that famous quotation from Judge Cardoza about a trustee. That a trustee is governed by more than the morals of the marketplace. I believe that a lawyer is governed by more than the morals of the marketplace. The final thing that I would say, and this is the most important thing that I'm going to say today. When a lawyer disrespects a judge, when a lawyer disrespects his opponent, when a lawyer disrespects the rules of conduct, that lawyer hurts me, and he or she hurts you. Because any time you hurt the profession, you hurt each and every member. Thank you very much. Thank you.
On? Now it is. I can personally vouch for Ed's mentorship. Before I came to law school, I worked for a year at Ed's firm, and I saw him in the hallway one day, and he asked me, son, have you chosen a law school yet? And I said, no, I haven't yet. And he asked me why, and I said, I'm struggling to choose between Tech and Oklahoma. And he said, well, where do you want to practice? And I said, Texas. And he goes, why would you ever leave the state? That was one of the greatest pieces of advice I've ever gotten. I would not be here today if it weren't for him. Before we take our break, I'm going to announce the winners of the Southwest Bank raffle. There are 12 of them. You'll need to go to their booth. I don't know the winner of the Estate Gen one yet because I haven't found Mr. Winner. But when I do, I'll let you know or I'll email you after the fact. The 12 winners are F. Matthew Flores, Daryl Guthrie, Shyla Buckner, Teresa Potts, Travis Tooley, Spencer Piercy, Jacques Holt, Lorna McMillan, Suzanne Fenner, David Berman, Riley Branch, and by a stroke of luck, Professor Jerry Beyer. We'll be in break until 3:25, and then we'll have our final two speakers for the day.